The full bios for our speaker is on the WebEx information page for this webinar, but I want to briefly introduce today's presenters. Matt Bolesky is a research analyst with the Statistical Analysis Center at the Arizona Criminal Justice Commission. His work focuses primarily on the use of data from Arizona's criminal history records to conduct research, including on the topics of sexual assault case processing, identity theft arrest, and disposition, and the completeness of criminal history records in Arizona, among other criminal justice issues. Mr. Bolesky also provides valuable web development expertise for specialized projects at the state administering agencies. And Matt is an active member of the Arizona Injury Prevention Advisory Council, IPAC, and is an ongoing participant in committees charged by JRSA. Mr. Bolesky received a BA in psychology and a BA in sociology from the University of Missouri-Columbia, and his MA in criminology and criminal justice from the University Missouri-St. Louis. Now, I'll turn it over to Matt.
Thank you, Sue. Good afternoon, everyone. Again, my name is Matt Bolesky. I'm a research analyst with the Statistical Analysis Center of the Arizona Criminal Justice Commission. I'm really excited to take this opportunity today to lay the foundation for future criminal history record webinars by sharing the work that we've been doing out here in Arizona using criminal history record information. This webinar is going to be looking at an overview of the criminal history records here in Arizona, along with some of the research projects that we've worked on over the 8 years that I've been here at the Statistical Analysis Center in Arizona. Just a little bit about the webinar structure. The first part of the webinar is going to be looking at criminal history records defined, looking at the process of getting that information into our centralized repository, looking at the specific extract that we receive from the agency that oversees those records, as well as exploring some of the benefits and the limitations of using criminal history records for research. After that first part, we're going to have a quick Q&A, a question and answer session, so I would recommend that anybody that has questions for that first section to please go ahead and submit that information as quickly as possible so we can include you in that question and answer portion. Then we're going to go in the second part of the webinar, looking at the projects that we perform here at the Statistical Analysis Center in Arizona using criminal history records. And then that second part will also follow with a question and answer on those specific projects. So please be sure, if you have any questions, to submit it at those appropriate times where we're able to put that into those question and answer pieces. So to begin, I'd like to cover the basic concepts regarding criminal history records for anyone that may be new to these records and are joining us on this webinar. There's two fundamental criminal justice components to criminal history records, as we know across the states. First is the information that's collected at arrest booking, and then followed by subsequent case disposition findings, either from law enforcement, the prosecutors, or the courts. Such findings would include charges not referred to prosecution, any charges that are not filed by the prosecutors, charges that are dismissed in court, acquittals, convictions, and any other court findings resulting from those arrest charges. We also see in many instances that the sentencing information is included as well. Criminal history records are used for some very vital purposes throughout the nation. We see that they're used for checking one's criminal background for employment and other purposes. We also find that federal firearms licensees across the country use what's called the National Instant Criminal Background Check System, known as NICS, to determine the eligibility of a firearms purchaser. And NICS hits on those criminal history records that are collected at the Federal Bureau of Investigation's III, which is the federal repository of criminal history record information from across the states. There's also specific uses of criminal history record information within the state of Arizona, not just background checks for employment or firearms eligibility purchases, but also law enforcement uses these records to establish the identity of an offender when they pick someone up and bring them into the booking station. The courts can also benefit from using these records. We have 2 pilot counties in the state of Arizona that are looking at using 2 fingerprint identification technology, where they're able to identify that defendant that showed up to make sure that's the correct individual that should be in court. They also use that information for other purposes. Let's say if an individual does not have a criminal history when they do the 2 fingerprint ID at the court, they know that individual now needs to go in for fingerprinting because they haven't been fingerprinted on those original arrest charges. Prosecutors across the state will use these charges to assess the level of risk for defendants' failure to appear. State statute also allows for the sharing of the records information with the Department of Child Safety here in Arizona with regard to adoptive parents and existing custodians. And then finally, prosecutors and the courts use these records for charging and sentencing decisions. So for example, with aggravated domestic violence, prosecutors can look at the criminal history information, find out if there were those 2 prior convictions for domestic violence, and in a case where they've picked them up on a 3rd charge, they can elevate that charge to aggravated domestic violence. So now let's look at how we define the criminal history records here in Arizona and how that it plays out through ARS 41-1750, which is the statute that outlines the information that's supposed to be collected, as well as the specific offenses that apply as fingerprintable offenses going to the ACCH. The arrest information that is required for entry is all the arrest charges, offender information, fingerprints, and the process control number. Subsequent case disposition information would include any amended charges, disposition findings, any sentencing information from incarceration, fines, probation, as well as other penalties. The fingerprints at booking kickstart that records process here in Arizona into the Arizona Computerized Criminal History Repository, which is known as the ACCH. That is our centralized repository of criminal history record information. So when an alleged offender is fingerprinted at a live scan machine by law enforcement, those fingerprints and the arrest information is automatically entered into the ACCH repository. Law enforcement, prosecutors, and the courts, once that fingerprint information is received into ACCH, can then submit their disposition information as well. State statute identifies specific offenses that must be entered into the ACCH repository. According to ARS 41-1750, these would include felony charges, driving under the influence charges, sexual offense charges, and any charges for offenses involving domestic violence. This includes charges for any offender or defendant who's been charged, arrested, summoned, or convicted for those specific offenses. We do see that many agencies across the state enter charges beyond these requirements, and we believe that is because when using LiveScan, agencies are submitting all of their offenses that they process through the fingerprintable LiveScan device. So we're receiving far more than the allotted offenses listed here, which is a good thing. We're not going to complain. More records means better research. The ACCH repository is maintained by the Arizona Department of Public Safety. DPS is also mandated to oversee the state's uniform crime reporting effort, as well as the Arizona Criminal Justice Information System. So in a sense, DPS really is our centralized hub of this criminal justice information for the entire state of Arizona. The ACCH repository is 100% electronic. However, the process of collecting that information is not. Efforts are ongoing to automate a predominantly paper-based disposition process in Arizona, and a variety of, there are quite a few, I should say, agencies that are submitting paper-based. We also see small numbers of arrests that are still ink and roll. Those dispositions that are paper-based are required to be mailed to DPS in a expedited fashion to try to get that information into the ACCH, along with those fingerprint cards that are still processed via ink and roll. But those are very few numbers, my understanding, for across the entire state. This is the process in a nutshell of collecting all of this information. It's a nice little flow chart. It's very simplistic, but it really kind of outlines exactly how that information makes it into the ACCH and how, in theory, it should all go in. We see at the start of arrest, law enforcement will book or fingerprint that individual. That information through LiveScan is submitted directly into the ACCH. That's not always the way the process works. We do know that there are cite and release offenses, as well as long-form complaints where the individual is summoned to court. For the cite and release offenses, there is a mandatory fingerprint compliance form that goes along with that citation, requiring that individual to show up at a booking station for fingerprinting prior to their first court appearance. This form is not the end-all, be-all. There are many offenders that do not comply by that form. They show up for their first court appearance. That's when the judge is required to order them to fingerprinting at a booking station, as well as those that are summoned to court. So it's really up to the judge to get those individuals into the booking station and fingerprinted. Once they've been processed through booking and fingerprinting, then their information is also entered into the ACCH. So once booking and fingerprinting is complete, the disposition form, that yellow form there that you see being passed around across the agencies, that's what holds all the disposition information. So law enforcement will fill out that form. If they choose to not refer on any of the charges, then they will pass that directly to DPS for entry into the ACCH. If they choose to refer those to the prosecutor, that yellow disposition form goes directly to the prosecutor. Then the prosecutor decides if they want to file on specific charges. If they choose not to file on any of the charges, then that information is submitted directly to DPS for entry into the ACCH. If the prosecutor does decide to charge or to file any of those charges, they then submit that disposition form directly to the court for them to conclude on that case, to put in their findings, as well as any subsequent sentencing information that goes along with those charges. And then that information is submitted to DPS for entry into the ACCH. All of those charges on that disposition form are to be lined up with the arrest charges at booking. So there's order to the way that those charges are displayed on that disposition form, and there's a process that the law enforcement agencies, the prosecutors, and the courts really have to abide by in order for that information to make it and line up one for one for each of the arrest charges in the ACCH. There's a couple additional pieces. This is really reiterates what I mentioned on that previous slide, but I did want to make a couple notes. We have found that law enforcement agencies are booking at booking facilities the majority of the time, but we do see that some courts across the state have sworn officers that are dedicated to fingerprinting within the court. So when the judge orders that individual to be fingerprinted, that sworn officer is available to fingerprint on the spot in that court, and then they can continue with the proceedings from there. And then also, as I mentioned earlier, it's really crucial to line up those arrest and disposition charges so that DPS can enter that into ACCH. So when the prosecutor amends an arrest charge, they have to be sure to enter that information on the disposition form. Otherwise, DPS would not be able to line up the final disposition offense with any of the charges that are in the ACCH for arrest. So every agency really has they're a crucial piece in this process to get that information into the criminal history record repository in the state of Arizona. And just a couple more pieces about the ACCH here in Arizona. We see lots of additional offense codes, as I mentioned earlier, outside of the required 41-1750 offenses. As I identified previously, these offenses range from misdemeanor failure to appears, drug offenses, traffic violations, even local ordinance code violations, and many others. So it looks to us like agencies are submitting basically everything that comes across the live scan machine when they're fingerprinting an individual. We also see that cases that are appealed, any findings that are made in appellate court will replace the original findings from the courts previously. So that overriding factor is a bit of a complication when running research. It basically erases the information that we have from the prior conviction that led to that appellate case process. And then DPS is currently recruiting disposition agencies across the state to take advantage of the Arizona Disposition Reporting System, also known as AZSAC, which is really the latest electronic disposition reporting system. We have a prior system called eDispo, and that's being phased out, and we're starting to transition agencies over to AZSAC, which is a very robust tool, but we need both the prosecutors and the courts on board. Otherwise, we run the risk of this being a duplicate entry process, where if the prosecutor's using AZSAC but the court is not, the prosecutor still has to process that paper through the system to the courts, as well as enter in on AZSAC, and that creates some complications with dual entry. So now I'd like to discuss a little bit about the history of our collaboration with the Department of Public Safety, those that house the records. We're now on a regular criminal history record extract process with them, but it wasn't always that way. With these earlier projects that I've listed here, I think they've really kind of created the groundwork to getting to that point where we have a regular extract process. So first, our annual sexual assault report is statutorily mandated. DPS is required to provide us with disposition information for all of the sexual assault charges that come to the attention of the criminal justice system. So since that's an annual report, we do need that information annually. So accomplishing that collaboration with DPS to obtain this information on an annual basis, an annual extract, really helped to improve the process of reporting for our statute mandates. We also had a couple Bureau of Justice Statistics funded state justice statistics program projects. Back in 2005, we looked at using the Records Quality Index for county-level records quality indices. This was intended to assess the quality of criminal history records from year to year within each county in Arizona. We only have 15 counties here in Arizona, so it wasn't a monumental task like I know maybe for other states, but we were able to provide county-level reports on the Records Quality Index. That was created by Structured Decisions Corporation, and we, to this day, still use one of the components of that index to monitor the completeness of our records here in Arizona. And then also in 2007, we used SJS program funding to conduct a recidivism study of prisoners released, all the way back, dating back to 1985. We were able to use Department of Corrections information, ADC information, and combine that with some criminal history record information for those reports. I'll talk a little bit more about that when we get to the second part of this webinar. So we accomplished continuity in the extract process when DPS required a non-disclosure agreement back in 2009. As a result of that agreement, we were able to formally establish an annual extract process with DPS where ACJC would be given 13-year extracts every January. We've since revised that process. We're now receiving extracts on a semi-annual process, once in January and then once in July. So we do have that information as well for projects that come later in the year. So we have the most up-to-date information that we're able to provide. In turn, the Arizona Statistical Analysis Center sought ways for ACJC to really give back to DPS through this data sharing agreement. And we felt that the agency needed to be provided records quality data when the DPS Access Integrity Unit went out on their agency and county-specific audits. We wanted to provide them with useful records quality information so that they were aware of where those specific agencies and those counties were in their records quality. And so for a couple of years, we were providing them with that level of information, and we felt that it was really important to continue to build that relationship, show them the utility of using this information for records quality purposes, and meet a need that they could see value in. Through this agreement that we have, we also provide DPS with all of our deliverables. Any of the reports or data requests that we look to fulfill using criminal history record information, we always run that by DPS so they're well aware of what we're using that information for. And then also they review that and are able to approve of our sharing of that information prior to the dissemination of that information. So currently we receive the semi-annual extract every January and July, consisting of fixed width text files for every calendar year of arrest charges over the previous 13 years. I should note that each arrest charge makes up a single row. So if an alleged offender is arrested on 3 specific charges, those charges would make up 3 unique rows within those extract files. These are pretty large files on an annual basis that we receive. But due to consistent data collection over at DPS, we're able to use our syntax and really not change the design of our syntax, and can easily import those files directly into SPSS for use. We do physically pick up that data from DPS. We bring it back to our shop, and then we upload and import that information into SPSS. That process in all takes 1 to 2 days. So the accessibility of this information, the availability of these records is very impressive. Our July 2014 extract contained approximately 6.4 million records, and that's 6.4 million arrest charges that occurred over that 13-year period. So it's a very robust data set of information. It has crashed our computers in the past, and as we continue to work with them, we find different ways of maybe tackling those issues so that we don't continuously crash the SPSS program. But here you have listed the arrest and the disposition information that we collect in those extracts. This is not all of the variables that we receive, but those that we will typically use for our projects. We do not receive any personally identifiable information. Since we are not a criminal justice agency with an ORI, DPS does not provide us with that level of information. Only those agencies with an ORI, they'll consider sharing these pieces, because they don't take ownership, essentially, of that information. The owners are really the agencies themselves, and they just maintain that information at the state level. We do receive a state identifier, which is a unique identifier to those individuals that come across the criminal justice system, but it is masked. So we would be able to identify that individual throughout their criminal history, but we wouldn't necessarily know exactly who that individual is. We receive an arrest identifier, the process control number that's required for entry into the ACCH. We receive the date of birth, sex, and race of the offender, date of arrest and the offense, arrest information including the count, arresting agency, and one of the critical pieces you wouldn't normally think would be important in your research, but the entry date into the ACCH for the arrest and disposition information. we do capture that entry date on both ends, which we use for our records quality assessment of the completeness of the records. We also capture offense code as well as the charge type, misdemeanor versus felony. On the disposition side, similar information, disposition date, entry date into the ACCH. We also receive the offense code, the charge type, disposition findings, obviously, and then any subsequent sentencing information is available in those variables as well. We do also receive the disposition submission type, which would be paper versus electronic. So that would indicate to us who's using the AZSAC system, who's using the prior eDispo process for automated entry of the disposition information into the ACCH. And then also we receive the domestic violence flag. Domestic violence is not a specific statute charge here in Arizona, but those offenses where domestic violence is involved will be flagged for domestic violence. And that variable is present for both arrest information when they're arrested. We have that DV flag available as well as in the disposition information. And then finally, disposition agency ORI is also provided. So let's look at some of the benefits, the limitations of using criminal history records for research. One, I don't know if it really needs to be said too much, but the ACCH records information is a vast amount of criminal justice information spanning the entire criminal justice system, from arrest all the way through sentencing. And it's just been a very big wealth of data that we've been able to work with for a variety of our projects. So we do value the use of this information tremendously. The records repository here in Arizona is 100% electronic, and our extract process, as I noted earlier with DPS, is very simple, 1 to 2 days to get that data in-house and to be able to work with that information. DPS also follows strict guidelines for information submission into the ACCH. There's very little room for error in that process, essentially, and they adhere to strict standards. That does not necessarily mean that they're able to catch data entry errors from the agencies, but if what's entered on the disposition form does not meet standards, they will reject that information back to the agency for resubmission once those issues have been corrected. So there is, in a sense, checks and balances at DPS of entering this information. But really, since the agencies are the owners, what they enter, for the most part, is what is put into the ACCH. And then looking at the limitations of the data, as stated earlier, misdemeanor offenders who were cited in lieu of arrest, they may not have been fingerprinted for the originating charges depending on the court's response at first appearance. If the judge does not order that individual to go get fingerprinting, then that misdemeanor offender, we miss the opportunity to get them into the system, get them into the record system, and get their arrest and subsequent case disposition information entered. And then we also see that completeness of disposition information still requires some attention. Back in 2012, that's the last year of research that we have. We found that in 2012, 72.1% of the arrest charges were complete with case disposition information attached in the ACCH by the end of 2013. So obviously there's 1 out of every 4, roughly, arrest charges that are missing disposition information in the ACCH. This could be based on the paper-based process of disposition reporting. Could also be complications with collaboration across the agencies, trying to get that information into the ACCH. And we continue to monitor that completeness percentage in a variety of ways so that we're able to identify any weaknesses in the system. There's also the issue of the bookend approach to reporting this information. We see that we have arrest information, we have disposition finalized information, but not a whole lot in between. No filing information from the prosecutors or changes to those charges throughout the process. And then again, as I mentioned earlier, appellate findings overwrite the original findings from those records where there's an appeals process. So with that overwrite, we don't see some of the originating conviction findings in the ACCH. And then finally, one more point, DPS purges their records for individuals who they are aware is deceased. This is the standard process that they take. I don't know to what extent they research into those individuals that are deceased and how often that occurs that they'll purge those records. But we have seen in the past that those individuals are purged from the ACCH repository here in Arizona. So those are some of the biggest limitations that we have in using the ACCH records for research out here in Arizona. So this concludes part one of the presentation. I hope that everyone had a chance to submit any questions that they have regarding these specific topics that were discussed. So at this time, I'm going to hand it back over to Sue Burton, who will run the questions, and I hope I can answer them for you. Sue?
Sorry, I was muted.
Oh, that's okay.
I'm back. Yes, there are some questions. Let me read one from the list first, and it is, we're very interested in any findings about the accuracy of the DPS electronic records and about any steps taken to correct inaccuracies or to account for them in analysis. Can you speak to that?
I can to an extent. I will say, like I mentioned earlier, it's really up to the agencies themselves to be entering accurate and complete information to the ACCH. It's very complicated on our end. We don't have that auditing process built in here at ACJC. Many agencies, many statistical analysis centers who are housed within the agencies that maintain those records might have a better opportunity to do that. But DPS carries out their own audits of the records. I'm sure they look into that during those audit processes. So as far as I know on my end, the best that we do is when we're looking at completeness of criminal history records here in Arizona, and specifically that completeness percentage, dates are so important to understand when that information's been entered into the system. And we see sometimes that even the date of arrest will come after the final disposition date. Things of that nature where we also see an entry date on a disposition precede the actual disposition completion itself. Those date issues, we exclude those specific arrest charges when we're running that research for those records. So that's kind of a checks and balances that we have in our analyses here, and then I'm sure you could probably tailor that for the specific projects that you're working on, where you may be able to identify where that does not look right, and maybe you can approach it in a way that you account for it like we did for our completeness information. But overall, we do not have a specific process here at the Statistical Analysis Center to be able to do that, and I don't know if we have the capacity.
Okay, so that sort of answers another question that was submitted about records often having significant systematic missing data, so it can be difficult to satisfy the missing at random or missing at completely at random statistical questions, and how do you suggest we deal with this problem? I think you touched on that, but do you want to add anything?
I did see that question, and I do want to just add that when we finalize a project and put together that report of all the information that we want to provide, we always recognize the limitations to using this data, but we also want to let the data speak for itself. We will note when, for instance, if we're looking at disposition information, we note how many or what percentage of those cases are missing disposition information in the ACCH. We don't try to necessarily find ways of just looking at data that we do have, but also recognize the missing data for what it's worth. And I think that's extremely beneficial because one of our greatest projects that I've been working on for many years is that completeness percentage. Improving the records and acknowledging that we still have a missing disposition problem with ACCH records. So when we acknowledge that, people are receptive to that, they recognize that issue, and we're all talking now about solutions to those problems. And we're continuing that discussion to try to improve the records. So I think it's very beneficial to acknowledge that there is missing information. It can help us improve this process of collecting all of that missing disposition information specifically and getting that into the ACCH. And hopefully we're able to accomplish that goal of a gold standard percentage that looks really good, and we're really excited about the completeness of the records by that point. And that will just improve our research. And also one other thing, it will improve the process of checking individuals in the NICS system. If we improve the records, we also improve criminal background checks. We improve all of the daily functions of using those records. So I feel it's very beneficial to report out on what's missing so that we're all well aware of the realities of using this information.
Okay, we have some other questions. Let me ask one more, and then, Matt, if you agree, I'll keep the others for at the end.
Okay, yeah, that's fine.
You stated that judges are required to have the person's fingerprinted. How is that accomplished? Do you have a statute that mandates judges to order fingerprinting?
Yes. And that was put into place back when the mandatory fingerprint compliance form was up and running. That was legislation that was passed while I was here because we found an issue with those individuals that were cited and released getting into the ACCH. So that form came into place, and then as kind of a backup to that, because we're asking offenders, right, to show up and voluntarily be fingerprinted at a booking station. But if the judge, part of the statute is that the defendant needs to bring that form to the judge to indicate that they have been fingerprinted. And if they do not have that form or it's not filled out by the booking agency, then the judge would know to send them to go get fingerprinted. So we did as best we can in the process. However, there really is no kind of carrot and stick approach to getting the judge to do that. It's really kind of up to the judge to follow that statute mandate.
Okay, thank you. And again, we do have some more questions that we'll pick up after your second part.
Okay. All right, let me go ahead and switch this slide here, see if I still have control. Okay. So I'm going to start off looking at our 2007 recidivism study. The Statistical Analysis Center was funded in 2007 by the Bureau of Justice Statistics to conduct a recidivism study of Arizonans released from prison from 1985 through 2002. We did receive an extract from the Department of Corrections through 2007, but we leave that 5-year period for post-release follow-up for recidivism. So that defines recidivism where an individual that is reincarcerated within 5 years post-release from a Department of Corrections prison facility here in Arizona. So recidivism is essentially measured by reincarceration. Researchers at the Arizona State University were able to complete 2 recidivism reports. One was focused on drug offender recidivism. That's the one I'm going to look at a little bit today. I may have to kind of rush through it so we can get all of these projects in. So forgive me, I may not go through all of the findings, but I'll try to do my best. The report was authored by Dr. Nancy Rodriguez, an ASU professor at the time of the report. She has since been appointed as the next director of the National Institute of Justice. So we're very excited for her transition out to Washington, D.C. And it was co-authored with Dr. Jessica Saunders from the RAND Corporation. So let's take a look at the findings. We did kind of set some goals using the ACCH information that we had to build upon some of these findings. But unfortunately, as I mentioned earlier, we were crashing our computers back in 2007 using criminal history record information, and the rap sheet list that we received for prisoners released from '85 all the way through 2007. Working with that ACCH data, we had some major complications. So we weren't able to do quite as much as what we were hoping, but we were able to get these 2 reports, or ASU was, researchers were able to get these reports finalized for us. So in this first table, we're looking at the reincarceration rates of prisoners released across the various offender types. Violent drug offenders and property offenders were the most likely to be reincarcerated into prison at 54.7% and 55.2% respectively. Violent offenders were reincarcerated 46.9% of the time, followed by drug offenders at 43.1% and sex offenders at 31.9%. On this next table, this addresses the regression models related to reincarceration among prisoners released. Since we're discussing criminal history records here today, I'm going to jump down to the criminal history predictors of reincarceration. We find that the research shows that higher numbers of prior arrests and prior arrest charges increase the likelihood of reincarceration. However, drug charges in one's criminal history or in the most recent arrest reduce that likelihood of an offender being reincarcerated. Greater numbers of conviction charges in an offender's criminal history did raise the likelihood that that individual would return to prison within that 5-year period. So these are some of the findings from that recidivism study. Next, I'm going to just briefly overview some of our completeness of ACCH records findings over the years. I'm again going to say I think this is one of the many great uses of criminal history records that we have found here in Arizona, and I think it provides great utility to the agencies that are submitting information, to the Department of Public Safety to understand the quality of the records, and just for the public awareness of where we stand with these records, and that we still do see some missing information issues. And we need to address those because it really is a centralized source of information that many of us use, like we said, for employment purposes, as well as firearms, disqualifiers, so on and so forth. So with that said, I'll go into some of our completeness findings here in Arizona. We know that when discussing the quality of criminal history records, we found that it's imperative to have strong data measures for assessment purposes. So branching from our work with the Records Quality Index, we established a standardized approach to completeness of criminal history records in the ACCH. A completed record is defined here as one with disposition finding attached to the adjoining arrest charge. We do assure that the arrest charges are given at least 1 year for disposition completion, but we also limit that completion to up to 2 years so that we can compare that percentage completeness fairly across the 10-year period and assess the improvement. So here we see the overall percentage completeness for all arrest charges in the ACCH. The blue line represents the total number of arrest charges in the ACCH for that calendar year. The total increased from nearly 445,000 in 2003 to a high of 502, roughly right around 503,000 in 2007, and then it fell to just under 456,000 in 2012. The yellow line represents the percentage of arrest charges with subsequent case disposition information. So we see that the percentage has increased from 59.2% in 2003 up to 72.1% by 2012. We saw a dip in that percentage back in 2009 and 2010 after reaching 68% completeness in 2007 and 2008, but then finally eclipsed that 70% mark of completion back in 2011 and 2012. There's also a green line in there that indicates the percentage completed for just those ARS 41-1750 offenses that are required for entry into the ACCH. And interestingly, we see that percentage closely mirror the overall ACCH records completeness rate. And then one other point about this that I really do like is we see that finally in 2012, arrest charges are increasing, and so is that completion rate. So we see higher caseloads that are going through the criminal justice system, but at the same time, a completion rate that is continuing to improve. And in this chart, we're looking at the completion rates by the offense type. Felonies have a consistently lower completion rate in the ACCH compared to misdemeanors, interestingly enough. Nonetheless, both felonies and misdemeanors have increased in completion of disposition information over the entire 10-year period of the study. We found that felonies reached 67.9% completion and misdemeanors reached 75% completion in 2012. On this next chart, we're exploring the percentage of disposition charges by submission type over an 11-year period from 2003 to 2013. We see that electronic submissions increased from 12.8% in 2003 all the way up to 24.4% in 2013. Nonetheless, we see that blue line at the top, the paper process, continues to dominate these percentages. ADRS is continuing to improve on the number of records that are being submitted via ADRS, which is DPS's new push to the agencies to use that for automated disposition reporting. But still, we're seeing a predominantly paper-based system here in Arizona. We also assess the completeness of criminal history records with regards to the NICS disqualifiers. The NICS task force in Arizona identified the following disqualifiers that were available in the ACCH records for firearms purchasing. These would include offenders that are convicted of a felony, offenders convicted on a domestic violence-related charge, offenders that have been arrested and or convicted for a drug use-related charge, as well as offenders found guilty but insane. We do provide completeness measures for those first three disqualifiers to county representatives across the state for their review. Our Criminal Justice Systems Improvement Department here at the ACJC, they go out on site visits to discuss with agencies as well as all the county representatives on how to improve their NICS reporting of these disqualifiers into the ACCH, and we equip those individuals with this county level data to provide them with useful information where they can assess the improvement to their records. And the Arizona Statistical Analysis Center was awarded funding back in 2009 to explore felony case processing in Arizona using criminal history records. This was a multi-state collaboration BJS basically provided a code book of desired variables that they'd like to see if it's available in all of the state's criminal history records. Unfortunately, we weren't able to pull everything. The filing information was one that we just didn't have any information on. And that's that bookend issue again, where we don't know exactly what's going on at filing. But we were able to capture quite a lot of information, and I was pretty surprised when we work with that data, what we're able to find out. So we tracked the ACCH cases for alleged offenders that were charged with at least one felony charge in 2006. The total number of offenders arrested on at least one felony charge reached 65,808 in 2006. So we're going to take a look at those individuals here in the next two tables. For the felony offenders arrested, we found that greater than 50% of those offenders had at least one prior felony arrest. Nearly 55% had at least one prior misdemeanor arrest. And then looking at conviction information, more than 70% had no prior felony conviction available in the ACCH. 54% had no prior misdemeanor convictions. And then for the incarceration data, 11.6% of those individuals received a prior prison sentence, according to the ACCH data, and 38.9% received a prior jail sentence. And there is a little bit of a notation at the bottom. We found that 67 arrested offenders were excluded due to the purging of their records as a result of them being deceased. So we do recognize that in the data process when we're reporting out. We do provide these notations on some of those limitations to using the data. And then on the next table, here we're looking at the disposition information for those 65,808 felony offenders. Greater than 50% were convicted for any charge associated with that felony arrest. And then also, you'll note one of the pieces here is the pending or missing dispositions. That made up 25% of the total number of offenders. We were not able to track disposition information resulting from those felony arrest charges and any misdemeanor charges that were attached. So approximately 75% of those convicted offenders received a conviction for a felony offense. And then we also further broke it down by the most serious conviction charge. 37.3%, their most serious charge was a public disorder offense. A violent offense, 16.7% of those offenders, and then 23.1% for property offenses, and then 22.8% for drug offenses. The remainder of our projects fall into the category of offense-specific studies, where we look at the arrest and subsequent case disposition information and trend analyses on those specific offenses. One of our statutorily mandated projects, our annual sexual assault report, provides information on sexual assault-related arrest charges and any findings resulting from those sexual assault-related disposition charges. Also in 2010, our SJS program funding went toward 2 reports, one on domestic violence, as well as another on identity theft records available in the ACCH. The following charts, we're going to highlight some of those findings from these reports. So here we're looking at sexual assault-related arrest charges and sexual assault-related convictions per year. When I say sexual assault-related, I'm really just defining that as any charge for sexual assault, violent sexual assault, as well as sexual assault involving a spouse. So we found that the arrest charges fluctuated over the 10-year period. Arrests decreased overall from 335 in 2003 to 307 by 2012. And then convictions for sexual assault-related charges increased over the same period from 87 in 2003 to 126 by 2012. We see it tail off a little bit there in 2012. We see that pretty often when we do not standardize the ACCH data. We expect that when we get our next extract, we'll see that 2012 conviction total potentially increase because those cases have been given more time for disposition completion. And then prior years have been given more time, so those don't seem to change as much. But that most recent year, we sometimes see those numbers change when we continue into the next year. And in this chart, we're looking at the sentencing types resulting from those sexual assault-related disposition conviction charges per year. We found that prison sentencing was assigned to a greater percentage of convictions in 2012 when compared back to 2003. Jail sentencing decreased over this 10-year period from 2003 through 2012. Probation was assigned to at least 2/3 of sexual assault-related conviction charges across the entire 10-year period, with some pretty significant fluctuations, almost up to 90% there in 2007. And then I also added that green line, the suspended sentencing indicator, to show that a significant percentage of sentencing decisions were suspended to some capacity. We don't know to what extent, but we do know that sentencing was suspended in some way, shape, or form for that percentage of cases. And then we'll move to the domestic violence report. My SAC director, Phil Stevenson, put this together and authored the report. And I'm just going to go ahead and pull some of the arrest rate information. Again, we have a lot of these reports available on our website, so if you want to dig a little deeper in some of the findings, I'll note at the end of this presentation where you can go to find some of these reports. Here we're looking at domestic violence flagged arrests and aggravated domestic violence arrests, more specifically the rates for those specific arrests across the years. Domestic violence, as I mentioned, is not a statute charge, so we're simply talking about those offenses where it was flagged for domestic violence. But aggravated domestic violence is a specific statute charge. So we split those out, and we're taking a look at here the arrest rates for each. So while the rate for domestic violence flagged arrests decreased from 408.5 to 395.7 arrests per 100,000 residents, the aggravated domestic violence arrest rate increased from 5.0 to 9.1 arrests per 100,000 residents here in Arizona. So we do see that aggravated domestic violence arrest rate increasing, while the domestic violence flagged arrest rate has decreased overall over the 10-year period. And then finally, I wanted to throw this in. We actually did a webinar on the identity theft report back in October. So you can also access that JRSA webinar to find out a little bit more about our identity theft study. And I would encourage anyone that's interested in looking at that information to go back to that webinar and find out more. We also published that report as well, so it will be available on our website if you want to access that. Here we're looking specifically at identity theft-related arrest rate versus the ARS Title 13 Chapter 18 theft arrest rate. Chapter 18 is our theft chapter, so most of your more conventional theft offenses fall under that chapter. Identity theft is not part of that chapter, so we already had that excluded from these Chapter 18 theft arrests. And so here we're looking at identity theft related versus those more conventional theft arrest rates. While the conventional theft arrest rate was consistently falling after 2004, the identity theft related arrest rate rose significantly until 2008. Both rates fell in 2009 and 2010. They are on different axes, I should note that. So the left axis there is for the identity theft rate. The right axis is for the Chapter 18 theft rate. But what I wanted to do here is just kind of note the trends that we're seeing with these two different types of arrest rates. So like I said, if you're interested in the identity theft reporting, that information, again, go to JRSA, and we did a webinar back in October on that. It was titled the Identity Theft and Financial Crimes webinar. And that concludes the overview of the Part 2. Again, our published reports are currently available on the STAC publications page at www.azcjc.gov. This was really a quick overview of some of the projects where we use criminal history records for part or all of the research. So feel free, if you have any questions or would like to know more information, to reach out to me, contact me by phone or by email. And I'm absolutely available to answer any questions that anybody has. I think using these records for research purposes, whether it be to assess the number of arrests that occurred for certain offenses, or to understand more about the record's quality. Absolutely good uses of this information. We do have those limitations to the data, but I feel as we continue to improve on those limitations and we're able to get those dispositions into the ACCH in a more timely fashion, that'll only improve those records for better research in the future. And so I encourage anyone that's not using records at this time to absolutely explore the opportunity of using those for your research within your state. So again, I'm going to hand it back over to Sue for round 2 of questions about the project.
Okay, boy, that was great. Matt, you have lots of questions, and not a whole lot of time, so let me move to these. Some of them were answered during your second half of your presentation, so that's good. One of the questions that, let's see if I can summarize this. People want to hear about how to request like a bulk distribution of the data that you're talking about. I don't know if that means specifically your data or just generally, how do you go about getting that data from the repository? How do you request it?
Well, first, if it's not your agency that houses that information, I'll just speak to not Arizona specific first. If your agency that maintains these records, if you build a strong rapport with those individuals, that's what we've done here in Arizona. The past 8 years, it's been Phil Stevenson and I that have been part of this process, and just the 2 of us. And I think that speaks volumes, where DPS continues to see the same face, continues to have the same discussions. We've built a very strong rapport with DPS here in Arizona, and an outstanding relationship, and we've seen the same faces on the other side as well. So I think continuing to build that relationship, if that data is not available initially, and just simply making that request to that agency, then continuing to discuss your interests and reaching out to those individuals over time, it might help to expedite that process, essentially, of getting access to those records. As far as getting our records here in the state of Arizona, it's a complicated process. If you are not a criminal justice agency with an ORI, and I don't know what it would be like for someone out of state to request those records. So really that's kind of uncharted waters to me, but we do have access to that information. We're absolutely available if there's any interest in using that information for research, that we can provide maybe some of the findings if that's the best we're going to be able to do, or whatever the case is. So reach out to us and we can talk through that process a little bit. I don't know the accessibility of data at the FBI level, through III. I know that was one of the questions of how to obtain this information at the federal level, criminal history records at the federal level through the FBI. And I'm just not too aware on that process to really be able to speak to that. But it'd be interesting to see if that information is available to state agencies to run maybe some national research or look at the quality of records across all the states, something of that nature. So that's probably the best I could answer that question. But if there's any more specifics to that question, please feel free to reach out to me and we can talk through that.
Yes, on the FBI question, the little bit that I know secondhand is they do have a process. It's also a very involved process to request their records, and it requires IRBs and detailed research design, et cetera, and to get access to some of their records. We haven't been successful, I will say, but let's see. As far as that took me off of my question. Oh, there's a question about sealed records, Matt, and what is the process for you identifying or dealing with records that have been sealed? I don't know if you have expungement in your analysis.
I'm not too aware of that. I don't know if a case has been sealed. We don't have any access to juvenile records. That's something that, one, I don't think they collect. They may collect information on juveniles that have been processed as adults. But again, I'm not too keenly aware on that process. If they seal a record, gosh, I really don't know if I don't know. I don't know if I can answer that. And I think that's an outstanding question to ask, because if records are sealed in the repository, which I don't believe they would be, and again, we don't receive public or personally identifiable information, so we wouldn't really be able to trace that to an individual. Really, it's just all that information at arrest that's entered, all that information at disposition completion that's entered. And I don't know if it's ever really been mentioned what happens with sealed records, but that's definitely a question I feel like going over and asking DPS here when we're done with this discussion to find out if there are instances where they will remove those cases when they are sealed.
Okay. On that, I think you touched on another question that you may have seen. What do you do when the demographics don't match the date of birth, the race, ethnicity, et cetera, of the same individual don't necessarily match? I wonder if you have any statistics about those, and what is your strategy to resolve these issues if you are not getting those identifiers? Is that something you can address?
At this time, it's not. We did way back. We were receiving personally identifiable information in certain instances. But now we've really kind of abandoned that approach, and I think we can only go on the information that's being provided to us. And obviously that's very limited with date of birth, the sex and the race of the individual. We wouldn't really be able to identify any issues with that. Some of our research, we do look at demographic information. Age is one of them. Obviously, age at arrest, we're able to calculate that if we have their date of birth. And maybe some other factors that we do look at demographics for some of our research. But for other pieces like the records quality, it's not necessarily a concern, I guess, maybe about the quality of the demographic information as far as completeness is concerned. But that is a very valid point when we're looking at the overall quality, the quality of the submissions of that information. And really at this time, we are dependent upon those agencies to try to submit the best quality data that they have. And again, I think the only way that we would be able to assure that is through auditing that process, which DPS is charged with auditing those records. So at this time, we don't have any way to really identify demographic information specifically that is inaccurate or entered in error.
Okay. And there's a couple of questions that go to prisoner data. One of them is, why do other states not have prisoner criminal history records available to the public via the internet? I don't know if you can address that one, but and then there's a question that are you aware of any jurisdictions where the electronic criminal history information is used, tapped into to populate risk assessments used by operational agencies like probation, parole, prison, et cetera? So those are your two prison-related questions.
So the first one with prisoner criminal history records, there are, I think that's a state-by-state kind of question. There are privacy concerns here in Arizona, releasing that type of information to the general public. My experience has been that DPS holds these records closely guarded because it's not necessarily their data to share. They maintain the records, but they give agencies that ownership. So any individuals that would want to look at maybe specific prisoner information on criminal history records would have to go back to the originating agency that would have provided that criminal history record information. And I think that's the course that we've taken here in Arizona, continuing to provide useful information to those that need it, but also respect the privacy concerns of those individuals that go through the criminal justice system. So I think that answers the first one to the best extent that I can as far as releasing some of our records to the public. The second one, dealing with sharing of information for more local jurisdictional interests. One specifically, I think you mentioned the risk assessments. We do see that prosecutors, as I mentioned in the presentation, prosecutors are using criminal history records for their risk assessment for failure to appear. The extent of using that information or tapping into it for purposes of risk assessment beyond the courts, maybe sentencing or corrections, I'm not sure to what extent they would use that information, but I am aware that the prosecutors, at one point we were considering removing failure to appear arrest charges from the ACCH because many of the prosecutors were not closing out those cases and providing disposition information. Their intent was just not to file on those charges. And there was also a concern about who was supposed to close those out because they came from the courts. So we had that discussion, and prosecutors came forward and said, please do not get rid of those failure to appears. We use that for that risk assessment purpose. So we do see it used to some extent. We also know of certain agencies across the state that have come forward in interest to use those for recidivism studies in their local jurisdictions, which we are very excited about, that possibility of looking at continuing that research for recidivism purposes. So we do see some interest across the state to use those records for risk assessment, recidivism, research, and so on and so forth. But that's, to the best of my knowledge, that's what we know of here at our state agency. I don't know exactly some of the communications that go on at the local level.
Very good. I have a couple of quick announcements. We're winding down on our time, I am loath to say, but I wanted to announce that the poll is being launched, the one that asks for your opinion, and it's very important that if you guys will please participate in that poll. We are going to continue to ask a few more questions, and if it's okay with you, Matt, we may exceed 3:30 by a little bit, but I did want to just make sure that before we lose everyone, that I really want to thank Matt for a great presentation and everyone who joined. And we have quite a large number of people listening in. And we hope you enjoyed today's presentation, and that you'll join us for the next webinar on using state computerized criminal history records for justice research. Again, I'm going to thank you, but I'm going to continue on for a little bit more with the questions and until we get kicked off, if that's okay. And without further ado, one question that I'm interested in too, Matt, is do Arizona criminal records also include mental health information? And if so, how do you share those records among agencies?
We do not have maybe what you're thinking to be mental health information. Some information, like for NICS reporting, one of the disqualifiers is mental incompetency. And so we're able to identify some individuals through the court process that were guilty but insane. So those disposition findings where that code indicates guilty but insane, we are able to identify a mental health component there. There's also another code for, I believe it's pending due to mental incompetency. And that, I believe, although I don't know exactly the details behind that and how that fits into the mental health side of that, but I believe those two indicators would give a mental health component to our criminal history records in the state. But other than that, we don't have any mental health piece. And I know that's of concern because we want to assure that we're also getting those that are found to be mentally incompetent to NICS as a temporary disqualifier until it's found otherwise. So yes, that is of interest, but at the same time, we don't have access to that type of information in the criminal history records here in Arizona.
Yeah, that is very similar to what we have in Florida, just FYI. There is a whole separate database that has to do with mental health and specifically for STP. So that's a similar thing. Let's see, I lost my questions. I think we've already covered the access to federal records. That was one of the questions. I lost my place, and I do apologize.
Baby Sue, I'll note that if any individuals have additional questions that they think of past this webinar, again, I have my information up here. Please feel free to submit an email or give me a call, and I'd be more than happy. This is something I'm really passionate about, using criminal history records for research, and all of these questions are very interesting. So I'd be more than happy to field additional questions beyond the webinar.
And that passion shows. There is a question about more about the structured design process and what that involves. If you wanted to talk about that with the RQI, if you'd like to say a few more words about that was one of the questions that I'm looking at right now.
Okay. You know, RQI is a little bit in my rearview mirror. I'm trying to think. There were 3 pieces, and Sue, you might be able to help me with this because we both actually presented on the RQI years back.
Years back.
Yeah. There's a timeliness component. There's a completeness component. And then
quality.
I think quality, yeah. And that piece was answered by the agency that maintained those records. I believe that entailed how many records have been submitted to III electronically, things of that nature. So they asked a list of questions that would assess the overall quality. As far as timeliness and completeness, Timeliness is kind of just what it says. How long does it take for those records to get into the ACCH? There was an extensive equation behind that, and I think completeness is probably the one I can talk to the most. The way that we measure completeness now is we look at the specific arrest charge within that year. Let's say back in 2009. So we look at all the arrest charges that occurred in 2009, and then we give them an arrest charge end date of the end of 2010. So those arrest charges are given 2 years, up to 2 years, for entry into the ACCH. And then we exclude any additional arrest charges beyond that because we don't have information, you know, like if we're looking at 2013, we would only really be able to capture arrest charges that were entered by the end of 2014. So in order to create a true trend analysis, we have to create those cutoff points. Same thing for the disposition. So going back to our 2009 example, if the disposition was entered within that 2-year time frame from 2009 to the end of 2010, it was considered complete. If beyond 2010 for a 2009 arrest charge, that disposition came in, let's say, January of 2011, we would still consider that case to be incomplete, even though we may have had that record on hand. And those cutoff points are essential in order to assess the improvement that we've seen over time. So what we're doing is not so much where we're at with the entire criminal history record repository, but looking specifically at the process, the process over the years, how have we improved in the processing of those cases over the years. So when we say 72.1% completion for 2012, we're essentially saying of those 2012 arrest charges, what percentage were entered by the end of 2013. And that's a little bit more detail about that standardization process that we use. We also, as I mentioned, exclude any cases where the arrest dates are inaccurate. You know, the arrest date comes after the disposition date. Entry dates are off. We exclude those records. We also exclude appellate court findings because since it's been overwritten by the appellate findings, we don't have the original court's dates for date of entry on the disposition information. So we have to exclude those as well, otherwise we may be removing cases from finalization that are complete because the appellate court case process pushed it beyond that completion date. So that's a little bit more detail into the completeness measures that we carry out. And I hope that's kind of what you're referring to. I don't know if I can get any more technical. That's about as technical as it gets. So
that was very technical, and I'm impressed you remember that much about it. I see a couple of questions about, you know, the missing dispositions versus, you know, those ones that just never went to court, got dismissed. And if there's a way to tell if they're truly missing or were they dismissed. I know in ours we can see dismissed. But that's the question. The gist of the question is how those things are handled if a case is dismissed as opposed to it's missing, did not show up in the record. Right,
right. And especially those that are outstanding for a long period of time, right? And prosecutors that choose to not file on specific charges, the process behind that of getting those cases in, if the prosecutor doesn't forward that form, no one else will. So sometimes we've heard way back of boxes of disposition records that still have yet to be entered in because maybe they were rejected by DPS, returned back to the agency. They weren't able to line up the disposition findings with the arrest charges, things of that nature. All of this kind of contributes to that discussion about missing information. But more specifically to your point about court dismissals, We do have a specific disposition finding for court dismissals, and that has to be indicated on that disposition form. So when the court does dismiss any charge, whether it be charge A, charge B, charge C, but maybe they still have a different finding on another charge, they are able to enter in court dismissed for that specific charge, or they'll add a court dismissed finding onto a no file of another charge that the prosecutor entered in earlier. So it really follows charge by charge. In a perfect situation, in theory, it should work that any findings, court dismissed, deferred prosecution, deferred sentencing, we have codes for all of this, and that really needs to be entered in on that disposition form. And DPS really holds them true, holds the agencies true to entering that information in. Otherwise, it's going to be rejected and sent back to the agency. Beyond that, when we're talking about missing dispositions, there may be cases that are kept out of the criminal history records for good reason. That individual's out on warrant status, and they haven't been able to track down that defendant for years, getting that individual in. So I don't see a perfect situation where we're going to get 100% completion all the time. There will be those exceptions to the rule where a case is still open for those reasons. But we do see continued improvement in the percentages right now, hitting that 70% mark. We want to continue and push towards 80%. We want to try to push the envelope as far as we can on that percentage to reach that gold standard that I think we're all dedicated to reaching. So I hope that answers that question.
I think that was a thorough answering of that question. I'm going to give you one of the generic questions that will probably allow you to wind up and give us a summary one more time. And that is, what is the benefit of using criminal history records for research?
It's a question I could go on for a little while. I think we had a slide on it, but I have to absolutely agree that tracking cases from arrest through disposition and all the way to sentencing, what a valuable tool to understand how our criminal justice system works, to see how it's working in practice, and to assess the quality of that information. We do use these records to assess the felony case processing of information on an annual basis through one of our reports. We look at county level data monitoring, the percentage of cases that are disposed within a certain number of days. So we're able to look at this entire process and assess not only quality, but maybe look at the number of arrests for identity theft, something that we didn't know how many arrests were being made on that specific charge here in Arizona. Now we have an idea. It may not be a perfect data set, but we continue to strive to make it perfect so that when we do run this research in the future, it's as informative as it possibly can be. And I'll just stop there because I know we're limited on time, so I'll leave it at that.
All right. I know everyone joins me in thanking Matt, and we appreciate everyone's attention and even staying a little late. And Karen, is there any other announcements, or are we done for the day with this great topic?
I'd just like to thank our partners once again at the Bureau of Justice Statistics, and thank everyone for joining us today. And our next webinar, we haven't scheduled it quite yet. We're hoping for February 18th, and so we hope you can join us then. We'll make announcements as to exactly when it's going to be our next webinar on criminal history records. Thank you very much, and have a good day.